I'd like to talk to you now about the adjudication and disposition, key dimensions of the procedural history and life of this case in court. Unlike the shelter care hearing, which we've talked about, the adjudicatory hearing is asking that fundamental question: is the child without the proper parent? The shelter care asks a kind of emergent question: where's the child going to be tonight? The adjudicatory is a more intensive intrusion into the right of a parent to control their child, to have access, and to exclude other people from their child's life. And so it's a big deal from a constitutional perspective and from a practice perspective. The adjudicatory hearing asks the fundamental question: is the child dependent? Is the child without proper parental care and control? This is actually the language of the first of 10 possible grounds for the adjudication of dependency. These 10 grounds are articulated in the Juvenile Act and are set forth as pleadings in the dependent petition. And with the pleadings, the moving party, typically the Children and Youth Agency, is required to bring forth evidence in support of those pleadings or allegations. They really are like charges. And so the petition will carry a host, kind of litany of horribles sometimes. You're not going to see a lot of strengths in the document. It's intended to prove that the child has needs, and perhaps that the parent is not meeting those needs. The dependent question really gets back to parenting. Is there a proper parent in this child's life at the moment? It's not looking real far into the past. It's certainly not looking real far into the future. It's this present tense question, today and in the current space of time. Are this child's needs being met? The parent's not required to meet the maximum best level of care, right? We never empower government to require all parents to be everything for their kids. It's a minimum standard. This is clear in the statute as well as in the case law. Is the parent being responsive to the child's needs? Has the parent harmed the child? Is the parent able to prevent harm to the child? It's not about isolated incidents of neglect, but neglect is often a ground, a basis for an adjudication of dependency. Drug use, per se, is not ground for a finding. And so we talk about a hot screen. Very often in our work, parents are subjected to drug screens. More typically, that screening process happens downstream after the adjudication. And prior to that, of course, it's a search and seizure. But drug use can be persuasive. And certainly where the drug use is implicating parenting, where it's getting in the way of meeting this child's needs, well, it makes a big difference in the outcome of the adjudicatory hearing. Two important legal issues. The burden of proof is on the moving party, typically the county agency, to prove dependency by clear and convincing evidence. And the rules of evidence apply almost in their entirety. There are a couple of exceptions articulated in the statute and in the code, in the rules of evidence. But at the adjudicatory hearing, we have a fairly high level of procedural due process, protecting the right of the parent to control access to their child.
The number one rule is meet with your client before the proceeding. Please respect the wishes of the child, even if you don't agree with them. If your position as guardian ad litem as to what is in the best interest of the child is different from the child's wishes, make sure that you explain that to the child before the hearing. In other words, tell them what you're going to recommend to the court so that they don't feel blindsided or betrayed. Make sure that you encourage the child to participate in the court process and to speak up. It's really important for the judge to hear from the child's own lips, from the child's own mouth, what the child wants. And while the attorneys do a good job of explaining that, it really does make a difference in how I might decide the case or what emphasis I might place on what the child wants. And don't be convinced that because the child is a toddler, maybe 2 or 3 years old, that the child doesn't have something to say. They often have something to say, and it's often important. have consideration for the feelings of the child and the bond and relationship that they have with their parent. This could be simply by stating, I recognize that this parent loves the child very much, but Judge, I need you to understand these things, and these are my recommendations. Although you're going to focus on what the child needs, make sure that you focus on what the child wants as well. Being in foster care and removed from the parents is a very traumatic event in a child's life. And so sometimes asking or requesting things that the child may want is really important in helping the child adjust to the traumatic event of out-of-home placement. Don't talk down to a child. Most children don't understand the word condescending, but believe me, they know it when they see it. They will feel belittled and betrayed if you talk down to them in a way that makes them feel that you don't acknowledge that they're smart, that they have a voice in the proceedings. Don't interject your personal values on this child and the child's family. While we may think that our lives are perfect and we do things a certain way, that's not what you're here to decide, and that's not what the court decides. The court has to decide whether the child can be safely returned to the care of the parents, even if you don't particularly like their lifestyle.
Guardians ad litem, what are some of the do's and don'ts that you should be thinking about when you're handling these cases? A few big areas. One big area is contact with the child. Some guardians simply talk to the child before hearing, and it's very important to expand that. Go to visit the child as much as you can, make as much contact with the child, see the child in different circumstances if you can, let the child know that they can contact you in between hearings, and keep an open line of communication with the child and develop a rapport with the child. Not just representing what they've said or what you think should happen, but actually developing a rapport with them. What you really want to do is you want to be able to paint a picture for the judge in terms of how everything is going, not just come in with conclusions. You want to show the judge what's happening in this child's life, not just tell the judge. Some other do's and don'ts as a guardian are not to take reports at face value, not to discount what the child says, and to remember that your job is to give your opinion and your recommendation as to what you think is in the child's best interest, but also to represent to the court what the child wants, understanding that those two things can be different. Another important thing to do is when you're presenting to the court what the child's interest is or the child's wish is, it's important that you're ready to present evidence supportive of that wish of the child. Not just to tell them what the child wants or to paraphrase it, but to present evidence supportive of that.